In today's video, we will talk about sentencing after a guilty verdict. Hello, and welcome to Ask Professor Price. I have been a lawyer for more than 35 years and a full-time professor for more than 10 years. People studying law or criminal justice or working in the legal or law enforcement fields need to know how sentencing happens after a defendant is convicted of a crime. We will discuss the main principles behind why we punish people who are found guilty of breaking the law. We will also talk about the different sentencing options, types of punishments, and the death penalty. So let's jump right into sentencing after a guilty verdict. Our criminal justice system in America has one of 5 goals depending on the case. Could be retribution. In other words, a person did the crime, they have to do the time. It's punishment. Deterrence is another goal on why we punish people convicted of crimes. If people knew that there were no negative consequences for committing crimes, some people would have very little reason not to commit crimes. Having punishments of offenders is intended to have a deterrent effect on would-be criminals. In other words, they might think twice if they know that they might go to jail for 3 years or other punishments. Another goal of punishments of offenders is rehabilitation. The idea behind rehabilitation as a goal is that you reform the person, including things like job training or education, so that they have a way to make a living when they get back out in public, in society, that they have a way to make a living without committing crimes that will help them escape a life of crime. Another goal of punishment of offenders is incapacitation. To be put most bluntly, if a person is in jail, they're not going to be committing crimes, at least against the general public. If a person is executed for multiple murders, once they're dead, they're not going to commit additional murders. And restoration. One way of punishing offenders is to require them to basically fix what they broke. So it might be that some people vandalized the outside of a little mom and pop store, and their punishment might be that they have to repair the damage they did. If they took cans of spray paint and defaced the store windows, they might have to clean that off. Or if they sprayed hateful or racist images or words on the exterior wall of the building, they might have to paint over that. That would be restoration or restorative. Each of the 3 branches of government, the legislative branch, the judicial branch, and the executive branch, have some responsibility for sentencing. The legislature writes the criminal laws, which include sentencing guidelines or categorizes the legislatures determine what category a crime is. It might be a felony in the first degree. It might be a Class A misdemeanor. And they also decide on the range of punishment available for each of the categories of crimes. For example, for a Class A misdemeanor or for a first degree felony. In the sentencing decisions, both judicial and executive are involved. The judicial, meaning the judges, they're the ones who pass the sentencing decisions on to the defendant in court. They pronounce the sentence. The probation officers, prosecutors, and defense attorneys are also involved in the sentencing process. States usually have sentencing guidelines, and so does the federal government. Some states have mandatory minimum sentences. So it would not be just that a person might get sentenced to 5 to 10 years if convicted of XYZ category of crime. Instead, it might be that the range of punishment is 5 to 10 years and no less than 5 years. 3 strikes laws are when a defendant has been convicted of usually 3 violent crimes or 3 felonies. They could face life without parole. The concern about 3 strikes laws is that if 1 or 2 of the convictions were 20 or 30 years ago, and what they get convicted of currently as the 3rd strike would be a non-violent offense, they could lose their freedom for life. They could go to prison for the rest of their life without possibility of parole. Cruel and unusual punishment is prohibited by the 8th Amendment. Now, it has to be cruel and unusual. Getting locked up in prison or jail, many people would argue, is cruel. Not undeserved in some cases, but it's a cruel type of punishment. Unusual punishment might be the having to repair the vandalism or paint over racist graffiti. The 8th Amendment does not prohibit punishment that is only cruel or only unusual. The 8th Amendment prohibits cruel and unusual punishment. Types of sentences can include imprisonment, probation, fines, restitution, and intermediate sanctions. Restitution, by the way, is paying back. Like if a business defrauds customers of millions of dollars, they might have to make restitution of at least part of that. In other words, paying back what they obtained through fraud. And then there are intermediate sanctions as well, which can include things like drug or alcohol rehabilitation treatment. Or community service is another type of intermediate sanction. Please hit subscribe and thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results. The higher the videos are in the results, the more people I can help. Thank you. All right, now let's talk a little bit about the death penalty. The judge considers several factors when sentencing. When a defendant gets convicted of the right level of murder that is eligible, or the correct level of murder that is eligible for the death penalty. So not all murder convictions are putting the defendant at risk of the death penalty. If it is a case in which the defendant gets a conviction that is eligible for the death penalty, the judge will then review and consider the seriousness of the offense, prior criminal record, and aggravating or mitigating circumstances. In fact, judges consider these same 3 factors when considering other types of sentencing. For example, if the judge is thinking of sentencing someone to 2 years in jail or prison, but they want it to be suspended imposition or probation, they would look at the seriousness of the crime the defendant was convicted of, their prior criminal record, any aggravating or mitigating circumstances, before deciding whether to sentence the defendant to incarceration or probation or any of the other potential sentences. Please feel free to post in the comments your questions about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students, as well as people working as paralegals or in the criminal justice field, are the main audience for these videos. But everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing won't cost you anything, but it can help me to reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video about criminal appeals.